Can you hear me? I presume you can. Okay, back. My name is Vijay Nagarajan and I'm here to do this program. So I thought that in the first class, actually I prepared for 7 classes because that's what I thought it was going to be. So I was really relieved to find that there were actually 9, which meant that I had a bit of leeway to try to use this class to try to get a bit of knowledge about where you're from. So the first thing we're going to do is just have a few introductions, and then I wanted to explain the structure of the unit, tell you about the assessment that we're going to have. Then I wanted to go on to just revise some simple concepts on corporate law, but after the introductions perhaps there'll be no need for that, so I'll just gauge it then. And finally, I wanted to go through these 3 elements. Oh my goodness, lovely voice. I was not a singer, no. I think you know why. So the word modern, corporate and governance. So I wanted to mix the 3 up and ask you what you think those terms mean, and also, of course, share with you what I think they do. So firstly, I just wanted to find out a little bit about you. So where you are from, what point of the degree you're actually doing, what interests you in corporate law? Have you read some papers? Is there a beautiful story of insider trading that you really like, which you decided may be a quick way to become rich? Because the enforcement is so poor. Maybe that's what you really are thinking about. Or maybe you're thinking that it's good to have better CSR control in the economy. So I'd like to find out something about you. And also to tell me what kind of topic you'd like covered in the course. There's a bit of leeway, and as I said before, I like to take orders from other people. So certainly I'll be guided by things that you're interested in. Let me start off and tell you a bit about me. I was born in Bangalore, but my parents took me away to Sydney when I was quite young, which is why I have this loathsome Australian accent. But unfortunately, it's here to stay. So I've grown up there and I did all my degrees there, finished my school, did my economics degree and arts degree, and then my master's, and I finished my PhD in competition policy. I've written a couple of books and plenty of articles, worked in practice. Currently I am an associate professor at Macquarie Law School, and I'm also a consultant with the Asian Development Bank, where I work in a program called the Private Sector Development Initiative, which has me traveling all over the Pacific. So that's my background. I love corporate law because of the way it's changing. And I love the fact that there is a little bit of democratic participation happening in the way corporations function. That's what interests me. Things such as sustainability are becoming important. As you know, having a woman director in your corporations is becoming important. So the fact that corporations are no longer private vehicles, but in fact are changing to take on numerous social important issues, is what interests me, the transformations. So that's about me. So perhaps I can start with you. What about you? Because you've got a nice computer, a bit like mine.
My name is Shivan, and I am in the 5th year of the BA and I'm in corporate law because I've done courses where I've also did corporate law. I've done a lot of internships in corporate law, and I'm going to be working in one next year. And so I'm interested in learning. I don't think I need to go further into why I'm interested in corporate law.
Yeah. What sort of internships have you done?
So they range from, internships at law firms usually involve you assisting these firms and associate departments there on matters, the advisory, you work on an M&A transaction.
So any corporate matters that you've worked with?
Quite a few M&A transactions. You advise the related matters, but nothing, it's all over the place, so it's not really at one specific thing.
Any topic you'd like to see covered?
As you mentioned, the nature of corporations is changing. So corporate governance is not something that most firms usually involve themselves with. And so I'd like to hear more about how it's changing, what is changing in terms of director duties and topics that now with the opening of the financial sector in India, how it could possibly impact functioning companies.
Thank you. You know, I forgot how much Indians like to speak. I'm one too. I like talking as well. Because in the classes I have in Australia, I have Chinese students, Asian students, they very much don't like to speak. The American students talk and the Indian students love a chat. So it's really fun to be here. Thank you for that. I think you've covered everything really, but we'll keep going. What about you, sir?
My name is Samar, and I'm from Portugal. And so there's one particular case I was working on during my internship which involved collective investment schemes and all of these schemes. That got me really interested into how there are various regulators who regulate transactions for funds. And as for the topic, I'd like to see what I can't really say much about it.
Okay.
Yeah, that's all.
Thank you. That's an interesting topic. That's something maybe we can bring in when we look a bit more at related party transactions.
My name is Pritish. I'm also an associate. What interests me in corporate law, I'm still not very decisive about my career, so I'm still thinking about my options. So I'd like to explore both areas, corporate and litigation. And I like corporate law because it has a lot of elements you have to look into, and there are many rules which can be interpreted differently. So I'd like to know how all those interpretations work in different scenarios. And with regards to the topics, I'd like to see covered basically how corporate governance is to be done, and what the companies think about it, and how they deal with all these rules and regulations.
Thank you. Thank you.
I'm Akshita. I'm also from Portugal. And I think like Shrivastava, I've done a lot of corporate internships, corporate law firm internships. And I worked in M&A and project finance and all these sectors. And I guess that got me interested in how a corporation works and the different aspects of commercial law. And I've written a paper on women directors and management practice. So I think I'd like to have a discussion on maybe that and corporate social responsibility. I think that these factors are upcoming besides having interesting stakeholders.
Thank you. Thank you.
I'm interested very a student. I find corporate law interesting because there are lots of elements to look into it and it's changing. The topic I want to say covered is how corporate governance, how corporate law is changing people.
Thank you.
My name is Arthur. I'm a graduate student. Till now I don't have any corporate law. I put that into the law. So I won't be able to tell you.
It's a big, huge open road out there for you.
But the interest which I have I enjoyed in many corporate norms which they isolated me when in case a company basis. So
Sorry, I didn't catch
they
that.
isolated me when they discuss about corporate. That's why I was from
Okay, thank you.
My name is Sandra. I'm from the the reason why I want to go I have to learn something. So I think I like corporate. It's very interesting to see how the law really impacts the different decisions of the system. And with respect to the topic that I'm going to cover,
Okay, thank you. Wise decision. Caution. Fifth? Fourth, yeah. Are you all from Nalsar? So all of you are. It's funny how you're not. Okay. So all the Nalsar people should be nice to the non-Nalsar people. You know, try to invite them out. Thank you. Corporate social responsibility, number one. Definitely cover that.
My name is Kailash and I'm a second year law student of National Law University Bombay. And I don't I'm not much into this topic of corporate law, so basically I'm here to discover my interest in corporate law.
Oh, I think you'll be completely charmed.
My name is Kushbu. I'm from National University Mumbai. I'm a first year law student, so I'm still doing my first year law student.
Wow. Are you enjoying it so far? Oh, that's good, because bad things are going to happen soon. No, it's actually fun.
Thanks for the heads up.
Sorry?
Thanks for the heads up.
Yeah, no, you'll love it.
Hi, I'm Sushmita and I'm a social law student from Nalsar. So in the beginning of the semester, we've done a course called Comparative Corporate Governance, where we explored the possibility of big corporations and the corporate governance models that they run and how they would promote the market economy of the particular country as a whole. But we didn't have enough time, so we kind of stopped this way. So I'd like to see that.
So did you have a look at other kinds of governance systems, like the Japanese or the German? Right. Interesting. Thank you.
I'm fine. I'm Tokyo. And my main interest in this is like regarding corporate social responsibility. Though this I'm not in any course in this, I'm not part of the project also. So I can
Thank you so much.
My name is Sima Sharma and I'm a
Here? You are. See how they gang together?
So my area of interest is Indian licensing, corporate work and CSR.
Oh.
When the corporate can be looked at earlier, but as the laws involve volume, so the corporate so and what law can help a person license.
Thank you.
Myself, Shivam Kumar from PSN Law College. Area of interest regarding corporate law is because beside of doing the law, I'm also doing the CS law, company secretary.
I see.
And I'm much tilted towards the corporate sector now. So my main interest is corporate sector and to explore the corporate sector, how it will be and how it is. Right now, the area of interest in the particular topic in the corporate sector is regarding 137 contribution by the corporate, any sort of contribution by the corporate. And another is that how the corporate governance is at its base, how it is to be regulated in the India in regarding with the whole of the world now. What is the scenario in other country and what is the scenario in other countries, how it can be improved at par with the developed country and what can we do for the corporate governance. Actually, when we are talking about the corporate governance, we talk about the interest of all the stakeholders now. So, how the interest of all the stakeholders should be protected in corporate governance? That's what I have to say.
Thank you. That'd be nice to him in case you do his subject later.
Regarding the subject, I learned this is the corporate governance while working in the law firm in Bombay. My firm typically used to advise the national Indian promoters who suddenly realized that their companies are listed in India now. And then they were worried about this use of corporate governance, how to incorporate all the provisions. And that's how I got the work. And that's why when I went to a course outside, I thought that it would be worthwhile. Go at the conceptual level, practice help us learning. This is what the conceptual level
I've already talked to him outside, and we're going to get him to do a 15 or 20-minute lecture. Don't worry. Speaks so well, obviously has a bit of information, so we want to see what's really behind that. Whether there's substance or it's just all mirrors.
Yes, so, so my name is Nalsar. I'm an assistant professor here, and I take basic arithmetic on company law, and I have an elective on capital markets. I also take an elective on competition law. And yes, so basically it's my interest in corporate law. I did my specialization in corporate law governance, and I've been teaching for corporate for the last 3 years now. So I can say I'm interested in corporate law.
Yes, but do you mean it?
I do. I think corporate law, and it's a fascinating area in terms of data systems which that subject offers. The continuous change that happens, the tussle between regulators and the government and the stakeholders. So it's a fascinating area to study. And corporate governance is one area, say, for example, which has gone a tremendous amount of change in India with respect to. So all we knew about corporate governance a few years back was Law 49, which has gone a decent, good amount of change with coming of new legislation, where the regulators are more interested in protecting, or they say they are interested in protecting the investors and different stakeholders. So I would like to see, for example, this schools learn on different aspects of corporate governance, different aspects of, basically a comparison on the protection to the minorities and shareholders, for example. Yeah.
Thank you. Okay, I've got quite a few topics here that you've told me about. Ponzi, interpretation of rules, CSR, gender representation, criminal liability, change, minority protection. I think we can cover all that because they're all pretty important themes. So, thank you. And there's a revised schedule. Are you doing this unit? You're not doing this unit, are you?
I'm not.
Coordinator.
Yeah, why not?
Job.
Okay, everyone. So, basically, this is the materials that are fairly standard. They are put together from a couple of books that are available, and I just photocopied them and scanned them, obviously. So what I've tried to do is give you a bit of an introduction, but as we go, Sorry, thank you. As we go, I'll also give you further links to other articles that you can read for a little bit more of an exploration. The actual study guide, there is somewhere along the line, I think it's on page 4, there is an outline or a study pattern. That's what I had thought originally when I put it together in July, but I think it's going to be a bit tough to fit 12 in. So this is the new pattern that I've given you. But we'll cover most of the things that I've said. The legislation, as you'd be aware, is available on that particular website with the Ministry of Corporate Affairs, and you can download it. And you can have it easy at hand. Originally, I had put together an assessment plan that was this detailed assessment plan of 20% participation, an essay, an exam, but I was guided again by people who know better than me, who said maybe that's not the best way to become, to basically have students in the class. So I've changed the assessment pattern. And the assessment now is one essay, 2,500 words. I do like to encourage a bit of class participation, so I thought what we might do is have a little bit more small group discussion and perhaps a debate during it. And the debate could be, I suspect, on CSR, but it could also be on gender on boards, women on boards, and the economic cost or benefits of it and how we can sell it as a business case. So that's the pattern. Each week's readings are in this guide, but please forgive me because I will have marked lecture 1 here, but it's actually lecture 2. So the materials, when you say lecture 1, it's actually lecture 2. Everything else is the same except for lecture 7, which is a CSR debate. And then lecture 8 and 9 is fine. So if you please bear in mind that the materials, lecture 1 in the materials is going to be lecture 2 next week. Lecture 3 in the materials, lecture 2 in the materials is going to be lecture 3 and so forth. And then there's the insert, lecture 7, which is going to be the debate, which I'll talk to you about later. The assessment, as I said, is going to be one essay, 2,500 words. And I've been told that it's quite a good thing to encourage you to think about how to set out your essays, how to make an argument, and perhaps include a bit of a theoretical perspective as well, that is something that you wish to learn or students feel they'd like to improve on. So that's something I can certainly assist you with. The assessment, the kinds of topics that I thought may be important when I was pondering this without having met you was CSR, is it effective? Is the provisions in the Act effective? Independent director provisions, are they effective? Whether the protection of minorities should be increased, especially in relation to state-owned enterprises, where the state has quite a big control of what happens within a company. They're just 3 examples, but as I've said in this guide, in this revised class schedule, I'm happy to discuss with you a topic you'd like to do. If you want to improve your paper on women on boards and take a much more of a global view, a comparative view, looking at quotas versus voluntary provisions, such as the UK approach, I'd certainly encourage you to do so. And if other people wish to look at related party transactions or minority protections or the Ponzi schemes, for example, and how they're regulated, certainly it's a discussion that I would be very keen on having with you. So the idea is to encourage you to explore a topic that you're interested in, and through that topic try to view some of the corporate law provisions and also engage with some of the theory. So I should ask you any questions so far. Please feel free to interrupt me. I prefer a dialogue rather than a lecture. I have noted that some of you have said that you don't actually know about corporate law, and perhaps corporate law is new to you. So it might be beneficial to just start off and revise some very simple, very basic principles that give us this amazing entity called a corporation. A corporation is so freaky, really, when you think about it. Actually, the French had something like a corporation, but really, I suppose, the origins of a corporation in the common law world comes from this case, Salomon case. Has anyone, I'm sure this rings a bell, the Jewish bootmaker, blah, blah. Does anyone remember it? Yes, sir.
Basically, this case is about a separate legal entity of a particular company. Do you want me to explain the fact of this case? Or
Yeah, just the fact, a little bit of the facts, just to jog people. Because law is about facts, isn't it?
So this case is talking about the fact of this case is as follows. There is a person who is operating a one-person company, and all the family members is the stakeholder of that company, and after some time he sold the company to some other person, and then after the company goes insolvent, and he paid for the shareholder debenture of that
Right, okay, okay. Well, just, thank you. I'll just stop you there for a minute. So, for those of you who remember the case, does everyone have a bit of an idea? So there's a few people here who mightn't. So this case is set out in the early 1800s that this sort of event occurred. The actual case itself is in 1820s and the decision is made in the 1830s. But the case involves someone who was a bootmaker, and he migrated from Austria to England, and he just set up a little business making shoes. At this time in England, we didn't have something called a corporation. We only had something called a sole trader. I think you would all know what a sole trader is. Sole trader is if you decide to give people some tutoring. You're a sole trader because you're trading services. So it's on your own, sole, and you're trading. What that means is any money you earn is your income and you have to pay tax on it. You are earning the income. You are an entity as a sole trader, but you're also the same person who earns the money. So that's a sole trader. Now, if you decide to join with your friend because he has some skills that you think would be quite effective, he could mark some of the papers. This is a partnership because there are two people who are doing it. So when you get the money, generally the idea is the two partners split it equally. You can do what you want. You can change it and make it 70-30 because, you know, he's only doing a very small job or a very bad job. You can just give him 30%. So you can change it, but that's a partnership. But the idea of a partnership is you still are together working in this provision of service. You're still earning the money. You're still earning the money in your own names. So when you get the money, you will still be paying tax. And if for some reason you have actually bought a computer to start off this business, you will still have to pay the computer guys the money in your own name. And if for some reason your partnership breaks up, the idea is you join this together, you're partners, and you're both liable. So the computer guy can bring an action against you jointly, together, or severally, independently. So, but the idea is you still owe the money. You haven't created anything new. You're still the same individuals who are running the business. So when Salomon came to England and he was running this shoe business, that's how he was running it. He had 6 sons and he had a lovely wife. So he was running this business, and it was a bootmaking business. But during this time, there was lots and lots of strikes. There was a lot of trade union action because it's around the Industrial Revolution in England, and there was lots of strikes. So what he was finding was that a lot of businesses were going broke, and he didn't know how he could protect his own business from going broke, right? So what was happening is that you could order the goods, you could pay them, but the goods weren't being delivered to you because of strikes. So businesses were going, basically going belly up, as we say, or going broke, or not making a profit and closing. So he really didn't know what to do. However, there was this particular act that had been introduced at the time, which said, if 5 people join together, you can form a company. That was the Companies Act. 7 people. 7 people joined together, you can form a company. That was the particular legislation at the time. So he went to his advisor and said, well, what am I going to do? You know, it might be a good idea to form this company, but what does it mean? And the advisor said, well, look, it'll be a great idea. So you and your 6 kids can form the company. That's 7 shareholders, and you form a company. The funniest thing about a company is that you're creating a separate legal entity, different, completely distinct from yourself. So when you're a sole trader, there's no distinction. But when you create a company, it's like you've created this new person. And like any person, that company can die, and that company, well, actually most people can do that now. Like any person, they can actually give birth to someone else. Or they can decide to join with somebody else and create a smaller company, give birth to it. And because we're in a modern world, they can do it with many partners. So they can have create a subsidiary company, as it's called, with one person or many individuals. So the company is an extraordinary thing, but all this wasn't realized at the time. No one knew any of this. They just had created this idea of limited liability. They didn't really know how it was going to work. So Salomon had to go and he started this company. He thought, terrific. But guess what? He had to sell his business to the company. So there was the company, there was his shoe business. So he did it through a separate trust. He sold the business to the company, to keep things simple, and he sold it for shares, 20,007 shares in the company. A share means you have a right, you have some small part of the company. The idea is you own a small part of the company. Doesn't mean you have voice, doesn't mean you can go and do anything and fiddle around with it. It just, in theory, you have a small slice of the company. That's what it means. So he had 20,007 shares. He owned 20,001, and the sons owned one each. Remember, the wife's not in the picture, right? We won't worry about that, but she didn't get a share. But anyway, we'll just leave that. So, proceeds with this company. And of course, guess what? Company doesn't do well. Hopeless. Still going badly. Because who's running the company? Himself. So there's a new entity, but there he is, jumps behind it, and he's still doing all the same work. But he is separate from the company. The company is a separate legal entity. He is the majority shareholder. He is also the managing director of the company. Right? So, does that make sense to everyone? Okay. The company isn't doing well. So what he does is he has to lend the company money. A debenture is merely an instrument which is a written document which says there's a loan. It's an IOU money document. So a debenture is written and he gives the company more money, but the debenture is written for him to say that the company will pay him back. And this is supposed to be a debenture that has some priority. The company still goes broke. Everything just keeps going from bad to worse. And the company basically can't pay its bills. There is a small amount of money left, but there are lots and lots of creditors. The creditors are the people who have supplied the company with all the goods. The leather, they've supplied transport, they've done leasing of the premises. So they've provided the company with lots of goods and services. They are unsecured creditors because they don't have a written document. Salomon is a secured creditor because he has a written document, and the basic principle is secured creditors get priority over unsecured creditors. So then there's a small amount of money left. From memory, it's around £4,000 or so that's left. And the court has to decide who gets that money. All these people out there who are owed the money, or Salomon, who has the piece of paper. They decide Salomon gets the money. But it's not an easy decision. It goes through 3 court judgments. And it's decided in different ways in each. But in the end, they decide that this is a fantastic idea, and the law has to be, the way it's written means that the minute you incorporate your company or register your company, you have created a separate entity. And the law is written in a very simple way. It's got to be interpreted in that way, and therefore Salomon gets the money that is owed, and the unsecured creditors get nothing. Unfortunately, by the time the decision comes, he's very sick, and all the money is used to pay his lawyers. So it's not like he wins, hugely, but that particular decision makes an enormous precedent for us. What it says is, and that has stayed with us forever, what it says is once you register a company, you have created a different entity, a separate entity. The same person who created the company is called a promoter, promotes the company. The same person who creates a company as a promoter can be the majority shareholder. Under the Indian law and under most laws in most places, you can have a one-person company. So one person can create a company. And it's also decided so you can also be a creditor. You can lend the company money and you can become a creditor of the company. You become the managing director because you run the company, right? The CEO, usually that term is for public companies, but you can run the company. You can also be an employee of the company. So you can be one person who is the major shareholder, the employee, the managing director, and the creditor of the company. So what do banks do now? It's ridiculous, right? So that is a separate legal entity. The second thing that links to it is limited liability. And that concept also comes out of Salomon's case. That means that the assets this company has is going to be used to pay its debts. So you're a separate entity to him, to you. Your assets are not used to pay his debts because you're not related in any way. Similarly, when a separate company is created, its assets are not used to pay other people's debts. And other people, so my debts will not also be used to pay the company's. Sorry, my assets won't be used to pay the company's debts. So that's a huge principle, that the liability is limited to the extent of the share value, unpaid share value of this company. That's a second important principle that comes out of Salomon's case. So if you start a 1 rupee company, actually it can't be 1 rupee, can it? No, it's got to be, I read the act. What is it? 1 lakh. 1 lakh company, then it is a 1 lakh company, then that is all the money that can be used to pay the creditors. So you might rack up 30 lakhs worth of debts, but that lakh is all there is. So what do creditors have to do to overcome that problem? Okay, sorry? Sorry? Okay, they can increase the capital, but obviously guarantee. So the norm now is to try to get a guarantee. So if the company, if I'm the managing director of the company, what the bank or any creditor will do is say, that's fine, the company has got 1 lakh, we'll give you 30 lakhs worth of credit, but you've got to sign the guarantee saying if the company can't pay, you'll pay, I'll pay. So they're doing a contract to say if the company can't pay, I'll pay. So that is a really important principle, limited liability, and of course all the banks, all the creditors are trying to get around it. You have to. But that's the main thing about the Salomon case. And the Salomon case, because of English colonialism, has been dumped across the world. And that act has been dumped everywhere I go. So it came to India, of course, but all through the Pacific, these small countries that I go to all have the act from the 1860s or 1880s, this miserable little Companies Act that's been codified within their jurisdiction. So the important thing about a company is it makes a distinction between insiders and outsiders. Shareholders are the insiders. The outsiders are the creditors, the consumers, the community, the purchasers. There are some people in the middle, and that's the employees. They're kind of within the company because the company is a separate legal entity, but it can't do anything. It's just a silly chair. So the employees have to go and do the things. They've got to actually make the decisions on behalf of the company. So the employees have to make the decision. So the employees are in a special role. And a lot of corporate governance is trying to decide how to make sure that these employees are controlled. So the whole of corporate governance is to try to figure out what these employees do, these managing directors, not employees that can be fired, but senior employees. So that is very simply what Salomon's case is and what a corporation is. But there's one other concept that I loathe to talk about, but perhaps all of you would already know about it, and that is the concept of agency, which you usually learn in contract law. You know it, right? Okay. So, briefly, the idea of agency is something in contract law, and perhaps we can talk about it as far as a travel agent is concerned, because we all know about travel agents. So in contract law, the idea is you can't really go to the airline and buy your own ticket when you want to fly from here to Mumbai, like you have come. So you can't, so what you do, although no, you can, but anyway, I mean the internet will, but you know, in the miserable old days, like, 20 years ago, you had to go to a travel agent for everything. So you go to the travel agent and you ask for a ticket. The travel agent is actually an agent who is working, who is the middleman, right? It's an interesting thing. So the travel agent, so what is happening there is, who is the travel agent representing? Is the travel agent representing you, or is the travel agent representing the airline? You think the airline? Okay. Anyone else? So when you go to him and you buy your ticket, he's really taking care of the airline's interests. Okay. It's a contentious issue. It's a difficult one. Okay. Okay. So it's an interesting issue. So you see there's a middleman, and you've got to ask, are they representing the airline's interest, or are they representing your interest when you buy a ticket? Let's talk about a financial advisor, right? Well, you go to a financial advisor because you have some money and you want to invest that money. So you go to a financial advisor and you ask that advisor to advise you. Where should I put this money? And that financial advisor is actually in a bank. It's a subsidiary of a bank. Who is that financial advisor advising? You or the bank? Who is he representing, sorry? He's advising you, but who's he representing? Interesting. Okay. Clearly you're all going for the really... No, but it's interesting. Okay, let me just ask another question. A real estate agent, do you have those here? Great. I thought maybe, nobody sells property anymore. So a real estate agent. You go to a real estate agent, you've got the land. You want the real estate agent to sell your land. Who's he representing? You or the purchaser? Your interest. All right, so the real estate agent is a really simple example. The real estate agent is an agent of the landowner who has gone to him and say, sell my land. So the landowner is the principal. The real estate agent is the agent. And the purchaser is the third party. So there is the real estate agent is actually an agent of the vendor or the person selling the land. Does that make sense? So the real estate agent must always act in the interests of the vendor. So the real estate agent cannot go off to his brother and say, have I got a house for you? It's worth 1 million, but for you, 250 or $250,000. How about that? That's great. That's acting in his own interests. That's acting in the purchaser's interests. That is a breach of duty because he's not acting in the interests of the principal. The principal is in a vulnerable position. The principal has asked this agent to act on his or her behalf, right? So the principal is the one whose interest should be represented by the real estate agent. Financial advisor. If you go to the financial advisor, if the financial advisor is working for the bank, they've got to tell you, I'm an employee of the bank. So any advice I give you is going to be representing the bank. Otherwise, they can't act on your behalf. It's not properly contractual not to disclose that, right? So generally speaking, if you go to a financial advisor, an independent financial advisor, they are supposed to be representing your interests because you're paying them. Usually, that's the way it works. So usually who's paying them determines it. It's a contract. It's a contractual relationship between the vendor and the agent. And the agent is supposed to find a good purchaser for the vendor. It's a contract between the financial advisor and the advice seeker who's going up and saying, give me advice. And if the financial advisor is doing anything that is not in the interests of his client, he must disclose it. Why is this important? Well, it's important because the company can't act on its own. So the company has to actually have agents acting on its behalf. So what is being used is this agency principle you learned in contract law is being used to try to figure out what's happening within a company, to explain everything within a company. So let's just take that little example we started off with before. You're starting a coaching business, the two of you. So it's a two-person company. Now, you've established this company, but you're both directors of the company. Agency principle is that there is a contract between you and the company, right? Employment contract. Because that you will actually be the director, but you must always act in the interests of the company. Now, you are also shareholders of the company, and you decide to have a third shareholder. So you all have third shares, 1,000 shares each. Now, there is a contract there as well. So there's a contract between the company and each shareholder, and that is decided in the share document. You will get a dividend. You will be able to vote. So the whole of company law, whole of corporation works on contract. It's all about contracts, and they use agency principle to try to actually explain how you must act. You are the directors. Remember, with the real estate agent and the travel agent, the financial advisor, they must act in the interests of the principal. So you must always act in the interests of the principal, which is the company. You can never act in your interests. You cannot act in the interests of a related party or your brother or your wife or your aunt. It must always be in the company's interests. So agency principles is how you look at the corporation. So that's why there's the corporation's relationships are determined by contract law, existing principles of contract law, and that's why agency is important. When you look at directors' duties, they are all simply an articulation of agent principal principles. So the relationship. So the agent owes a duty of good faith to the principal. The director owes a duty of good faith to the company. The agent owes a duty to exercise care and skill to the principal. The agent has to act carefully with skill on behalf of the company. So that is how the company is formulated. But one more thing. What is the company? It's a chair. What is it? When you say the interests of the company, what do you mean? You mean the shareholders. So the interests of the shareholders is who you're representing. The people who actually put money into the company is who you're representing. So whenever the directors act, they must act in the interests of the shareholders. So if there's just the two of you who are directors, and if you're not going to question each other, and if you want to rip the whole world off with a huge Ponzi scheme, that's fine, as long as no one else comes and sues the pants off you. Does that make sense? But if you three are shareholders, then you must make sure that her interests are also taken into account. Because the idea is the shareholders' interests is what governs, what determines what the company is. So that's just a very brief idea of what the corporation is. And it's a crazy, crazy idea of an artificial entity that's been created that can do and go where individual cannot. I mean, don't you think it's weird? Like, an individual has to pay all their debts, and a company doesn't. Isn't that, like, completely freaky? Doesn't strike you as strange? Okay. So there's a good article that's been written called No Soul to Damn and No Body to Kick. And that explains what a company is, that the morality isn't there inside. So that particular chair doesn't have a soul or a body, which comes back to your criminal liability. You can actually put a person in prison, and that's what scares them. But a company can't be put in prison, which is why it's very difficult to govern a company, right? A company can't get the death sentence. I mean, so what if it gets a death sentence? It just starts up again. The same guys go and start another one, right? So it's, death sentence as in it's wound up. So the extraordinary thing is exactly as you said, the beauty versus the soullessness. So they're the things that really come out of modern corporate governance. All the efforts to try to actually govern CSR, try to get more women on boards, try to give criminal liability to individual directors is all about trying to reintroduce the soul into the company, include some sort of moral compass into the activities of the company. I just wanted to briefly touch on globalization and convergence. I think you mentioned at the back there that you had done a course where there were many different kinds of regimes that were available. So, for example, in Germany, briefly to mention it, they have a dual regime where workers are represented on a board. In Japan, too, workers are represented on a board. So they have different kinds of regimes, and this dual board where they have directors. So you have a company. Usually the way the company works, a common law company, is through a board of directors. If it's a big company, what's supposed to happen is the company is established, and the first thing that happens is that a director is appointed and a general meeting is called. And in the general meeting, permanent directors, secretaries to govern the company are appointed. That's the way in which the company starts off. So who actually manages the company is day-to-day the board of directors. But the shareholders can sack the board of directors. However, usually the shareholders are too busy doing other things to really bother. So that's why it's a problem. The shareholders aren't keeping a watch on directors. And as I said before, employees often aren't really considered when a company is making its decisions. The employees are not in the front of mind. It's shareholders in the front of mind. The dual company in Germany, the dual board, the idea of the dual board is one board which has employees represented and one board which has the representation, as we know, of directors. So directors represent shareholders, employee board represents employees. So this was supposedly a wonderful thing, and it is a gorgeous thing because it means that there is a little bit more participation, a little bit more sharing of benefits. So if a company, if the board of directors want to do something which is to maximize profits for the shareholders, and that involves sacking all the employees and automating many functions, it's unlikely that that will be passed by the dual board. So it meant that there was decisions being made for the company's, the company's existence wasn't just shareholders, but also employees. That was very similar in Japan. However, what we have seen with globalization is that the American model and the common law model of having just the board of directors has taken over. So when the corporation also decides to incorporate in Germany, in Berlin, and also in New York, it has to have two different systems. One dual board, one board of directors, single board. It has to have two compliances. it has to have two decision-making systems. And if you're going to have globalization and you're going to have shareholders across from America as well as Germany, the American shareholders are not going to be happy. And actually the German shareholders aren't going to be happy either. They're going to say, forget it, we're going to put our money in a company that just thinks about us. Does that make sense? So what has happened is that globalization has seen the dominance of the US model of a single board. So the idea of the dual board has really fallen off. Deutsche Bank, which is in trouble right now, terrible trouble, is an example which has proceeded to go for a single board. So a number of, many older companies now have single boards. What does that mean for India? What does it mean for Germany? It means that the domination of that single model in a global world is inevitable. As much as we might try to make our own individual dents into it, such as the CSR provision and so forth, it's unlikely that we can really diverge from that particular model, which is something that can attract capital from everywhere, and it can also be easily regulated in all jurisdictions. So just pause there for a minute, and now I just wanted to go through and talk about a little bit about what I mean by modern corporate governance. How is it different, and what kinds of concepts I'd like to introduce through the course. And just try to give you a bit of a coat hanger, a couple of coat hangers to be able to come back to when you're looking at the way in which corporate law is moving, and come back to the coat hangers and see how it fits. So I've just got some questions that I was put up there to talk about corporate laws and how they've changed. And the first question is, what change have you seen over the last decade in corporate law? And it's just a question to you to give me an example and to maybe talk about what do you think has driven this change in corporate law. So maybe the question is, why are you all interested in doing corporate law? Is it jobs? You've already told me a little bit about it. Is it the fact that you consider it unwieldy? You've said a little bit about that too. But I was just wondering if there's any story. I'm new to the Indian, I don't follow the Indian newspapers on a regular basis. It's only been in the recent past I've been trying to get up to speed. So can you give me an example of corporate law reform and why has it happened? Well, I suppose you know that the Act was introduced in 2013. Like you'd be telling me that, right?
And the board of directors, they can go on one person company, there is no capital bond, give a company, and the other thing is that for incorporation of private and public company, you can change that, you can easily go to the public company to private company and private company to public company.
Maybe just take one of those examples, just one of those examples you told. You gave me like 4 examples. Just take one of those examples and tell me why it happened. I know it happened in the legislation. And I know the example is that it changed, making it easier to go from public to private or private to public. Why?
That whatever things they are giving us, thinking ideally in a scenario that okay, we have the final rule for the incorporation of the company, so we are why instead of incorporation of company, we can go to the private
Okay, stop. Now, you've got to use some full stops there because I'm losing you. But I think the point you're making is there's greater awareness of forming companies and everybody wants to do it. So you want to make it easier. Okay. So you think you're saying that there is a demand, it's demand-driven reform. All right. Okay. So, all right, so everyone wants to kind of get in the act and make a company in a minute and change from private to public if they want to. All right, and the government's doing it. Maybe to attract capital from outside. All right. Anyone else? What changes occurred?
Maybe that the laws have become more less strong. It started moving towards self-governance rather than imposing regulatory compliances, and they've given more discretion to corporations to deal with certain situations or pass certain resolutions rather than reporting to the NSA or the legislature.
Okay, that kind of fits in your first statement about hard rules. So to come back, that they're moving more to self-governance. Okay.
That's not always the reforms or something like the concept of independent directors, which prior to any study only existed in terms of listing agreements that companies were supposed to comply with before listing, only applied to listing companies, and now this concept post-2013 has been extended to public companies over certain thresholds, and the requirement to appoint a certain number of directors is a third of the time known as independent directors. The requirement that's come in 2013 itself. That's a risky change. I mean, so it's not always so much the regulation. There's also been some sort of different regulations that have come in their place as well.
Okay, so the point that's being made is independent directors is something that's been introduced and mandated not just for listed but also unlisted. Can I ask you who's the driver of that? What is the driver? Did they just do it because it's nice or? Okay. And whose interests does that serve?
I mean, it serves the interests of the public interest. If it's a public company, then a large percentage of the shareholding might is likely to be held by the public, and it's going to be the interest of the investors and the shareholders.
Okay. All right, so the point that's being made is that independent directors are supposed to provide greater oversight and therefore take care of the interests of shareholders and also the community generally. So sounds like the idea that the government can keep an eye on every single thing that happens across the board is disappearing. Clicks to the previous point that what they're trying to do is get somebody else who they think's clean to keep things clean. So what's happening is that there is an attempt at including, or sort of almost delegating the duty and trying to actually create a structure which scrutinizes itself a bit more. All right, so independent directors, really cool thing that's happening. Anything else that's happened in corporate law recently that you think is interesting? So you've talked about the first point, which is making things easier, responding to the need, removing the cap. So making it easier. All of it seems to fit towards creating a more, creating a market, an economy that can attract capital and govern itself. So it's about creating enough laws that provide oversight for market governance. Does that make sense? Because let's face it, how is a regulator going to regulate the activities of Tata? How is the regulator going to regulate the activities of Amazon? What are they going to go and knock on the door and say, "Hi, I'm here to check your books"? I mean, what is a regulator supposed to do? It's pretty scary. The old model of going in and checking all your reports, submitting annual reports regularly, and scrutinizing the annual reports is no longer possible. They've got to move on to a different frame of thinking. I think you've given me some good examples there. Yeah.
To answer your question on the past 10 years, how easy it has gone, I think there have been steps towards standardization. Global standards, OECD and other required standards, these have been at two levels. One, initiative by the government as we discussed, and also eventually we had our own example of Enron and Alpha Indus and Satyam scandal and the Sahara case, where we realized that the economy and the market has increased, and now we need to have regulations which cater to such a market. So we came up with new listing guidelines. So we agreed that these are no agents like anything such as incorporated in our. This is all able to last them. And also, cross line of the so I think the move towards standardization went based and also communication.
Great. Thank you. Thank you for that's a great summary. For those of you who perhaps haven't done corporate before, just to sort of come back, the old law everywhere, like in going back to the Salomon case, actually required or was provided great oversight and control by the state, by the government. So what it said is you've got to form a company every year, you've got to submit your reports, and that would be checked off. If you were going to raise money from the public, the government told you all the things you have to actually ask and what information you have to provide. But as the market got more and more complex, and as the market has become global, the point's been made, the state, the government has realized it's going to be really difficult to actually try to do that task of policing each company. So in all countries, there has been a period of complete disillusionment, of uselessness. The government has not been able to actually regulate companies. And the Satyam and the Enron are good examples that have been brought to our attention. They're examples of failure. However, what has happened is now they're recognizing you have to create a market for companies, not just nationally, but globally. And if you're going to create it globally, you've got to then be able to attract investors from America to Indian companies, from India to American companies, and so forth. If you're going to do that, you've got to have a harmonization of laws. And you've also got to figure out how to create structures that can regulate itself. So have broad rules. No longer I'll come and knock on your door and check your accounts. It's you make sure you have an internal policeman who keeps you honest. You make sure you have a whistleblower or whistleblower protection, so that if you're doing the wrong thing and someone knows, it's easy for them to tell others. So they're creating structures which will try to regulate itself. So that's what's happening slowly. And that, I think, is the essence of what we're trying to do. So firstly, that's how corporate law has changed. But secondly, I've just stated that all these kinds of corporations are now regulated. Along with this, what's been happening is that all the government businesses are also becoming corporatized. So when they become corporatized, they're also adopting this board, but they're a bit schizophrenic. Part of them says, we want to do what we always did. And part of them says, we want to go out, be fair, attract money. So there is a schizophrenia that's coming about where they can't figure out exactly what model they're going to pursue, and that's going to take time. But all of them are corporations, state-owned enterprises. Previous government businesses are corporations. Banks that have been looting us for so long are corporations. They still avoid everything, though. Of course, now we have multinational corporations. And I've got one of those case studies of Bhopal. And then we have the single shareholder. So we started off with silly old Salomon, one guy, one dude, just trying to help his family and make shoes. He was an old Jewish guy, and he was just doing his thing. We have that particular law that now applies to multinationals, which has just grown. The idea has taken over everyone's imagination. But what I really want to talk about, and this is where I would like you, most probably I'll be coming back to, is the way in which governance happens. Remember, the course is called Modern Corporate Governance. Governance is much more than law. Law is just a very small subset of governance. Think about governance, think about a king, think about all those wonderful stories that come from Hindu mythology of governing. It's not about creating laws, it's about actually taking care of things, making sure things are done properly, taking care of people who, or fairly, even fighting a fair fight. It's supposed to be considering the environment, it's supposed to be looking after the kingdom. Governance is more than just a law in a statute book. What I try to do simply is I try to distinguish governance into different means, which is hard laws and soft laws. Have you guys looked at that stuff before? Well, it's just part of the sort of way in which I try to explain it, and it's sort of part of what regulatory scholars think of. So it's pretty simple. Hard laws, it's red. And soft laws are blue. Hard laws are basically things written down, like your 49. Like even the Companies Act, really. But soft laws are supposed to be more like recommendations, codes of conduct, things that you agreed to do. OECD corporate governance codes. So a hard law example is 135, which mandates CSR. Well, it's just saying you've got to give a certain percentage to CSR. That's a hard law. Often people say, oh, hard laws are much better than soft laws. Hard laws are effective, they're tough, they're red. Big stop sign, red. However, I just wanted to ask you about Section 135 and how effective you think it is. It's a hard law. Well, I just sort of found, you know. So I was looking at one of these reports, and it was talking about Reliance Industries, and it said that in 2014, only Reliance of the top, this is of the top 10 companies, and what they have been spending on CSR. It said that in 2014-15, only Reliance had spent more than the prescribed CSR among the top 10. But in 2015-16, 5 companies among the top 10 were spending more than the prescribed CSR. So it seems to be suggesting that there is greater attempt at complying with Section 135. So it's saying that the companies are actually obeying this rule. However, the criticism that's made in that same report at a different page is that they're not perhaps reporting it in the format that's required. So there is a format, a guideline that's provided, and they argue, or they're putting forth the point that perhaps they are hiding some things by not saying where the particular money is being spent, who are the implementing partners, what is the budget. So they're just claiming to have spent the money, but not giving sufficient details for scrutinizing and actually figuring out if there's real compliance. So although you can have a hard law, and on the face of it, it looks like there is compliance, perhaps there isn't. Who is going to go and check that out? Who is going to check whether compliance of hard law occurs? So obviously the government can, and obviously the regulator can. Anyone else? Okay, so I just wanted to put forth this idea of hard law. And that's a hard law because it's written in the book and that it's written in the statute, and that's what you're supposed to do. Soft laws, sorry, the computer didn't work, so I couldn't actually print out my little definitions of soft laws, but soft laws are voluntary, and they can be made by either the government or they can be made by non-government bodies. The non-government bodies could include business associations, could include the OECD, could include the UN Global Compact. So it could be international or it could be professional bodies like the Indian Chartered Secretaries or Chartered Accountants, or it could be the Directors Association. So soft laws generally work on persuasion. They don't usually have a fine. They often don't have a regulator who comes and checks, but they work on persuasion. And they usually are recommended guidelines, or they can be standards, like accounting standards that must be adopted. So the soft laws are not in a statute. They don't have to come from the state government, from the actual government, which is quite different to the way we view law. The way we view law, and what you would have done in your course in corporate law, is the Act, the regulator. The government introduced the Act. But I think we've got to move away from that when we look at corporate governance. An example of a code, a soft law, is the corporate governance codes that were approved by your regulator in 2014. These codes were actually developed by a professional body, and then they were put forth and they were accepted, the same as the accounting codes. But I suppose what's happening here is if a regulator, which is government, well, it's not semi-government related, semi-government, gives credit to it, I suppose they're kind of making the soft law a bit harder. But it's still not hard law. It's still a soft, voluntary guideline. So persuasion seems to be the way in which governance works much more than hard laws. No stick, but it's a carrot perhaps. Or it's just trying to change norms. So what is the take-up by companies? How effective are they, these sorts of soft laws? Oh, sorry, why am I doing that? So I just wanted to give you an example. Well, you can talk about a whole lot of things, but how do companies take them up? I suppose here you've got to ask the question, who are the companies responding to? Who are the companies actually taking note of? The World Bank issues indicators every year. And if the country doesn't have the proper regulation, doesn't have the proper codes, they give a country a very low rating, which means people don't invest. But if all the countries take it up, then the ability of investment, the investment climate apparently increases in these ratings. I hate ratings because I think they're not nuanced enough, but it is important in the bigger picture. Now, the soft law, I looked up a couple of, it's interesting, the soft law in 2014 is to try to have a whistleblower policy that would establish a process whereby the employees can report to management any unethical behaviour or suspected fraud. So that is in a code of conduct, whistleblowing. The code also requires companies to disclose how they decide remuneration, how much money is going to be paid to the top directors, the top management. So that's not in the Act, but it's in a code. What are they hoping, can I ask you, by disclosing that information? Yeah. All right. I suppose I've been looking at some, so you would be aware of what companies do. What companies have done taking up these codes is they've tried to develop their own in-house policy on how they're going to give effect to the code. So they go through and say, this is how we're going to disclose remuneration policies. And I suppose they're hoping that that will be read by shareholders. And if the remuneration seems excessive, then the shareholders can complain. So it's only with information that shareholders can react. So what this code is doing is actually forgetting about the government, because the government's got to come and knock and say, excuse me, how much are you paying? What is your total generation of profit? Is this percentage actually working? So the government's unlikely to do that, but if there's disclosure, then shareholders will be able to check whether that hard law is being breached. But without disclosure, nothing's going to happen. So disclosure is for whistleblowing and for those incomes and also market-sensitive information. So anytime there is a change, such as some sort of oil spill, for example, it's got to be disclosed immediately because it might affect share price. And it's very difficult for a government to decide what is sensitive information. Is the fact that a managing director or CEO is sleeping with a director sensitive information? I don't know. No one knows. But the shareholders know. So if the company thinks that that can affect share price, they've got to disclose it. So what is happening here is the responsibility is being put on the company to decide, not the government to decide. Back to you, sir. So this is an example of sometimes where codes start off as codes, but in the end they become hard law, and that's just the example that was brought up before, which was of executive directors. So in 1998, it was a code, and it was talking about independent directors. In 2000, they were recommending again that this code should be strengthened and become law, and then it became law in 2013, and as you mentioned before, applying both to listed and unlisted companies. So it's an example of soft laws becoming hard laws. And usually the other way doesn't happen. Once there's a state government that's actually taken over something, they're not going to make it a soft law. But so what I want to talk about in this unit is partly the change in governance, that the governance is moving away from state-centric legislation, and it's moving away very much to codes of conduct, both built by professional bodies in the country as well as outside the country, particularly the Equator Principles, the UN Global Compact and so forth, which are trying to generate some oversight through soft laws. The next thing I just wanted to point out is all the literature I've been reading talks about the lack of, I suppose, all over the world, that's not true, all over the Asian world, it appears that shareholders are not active. Shareholders basically don't really seem to go to meetings. they've got this whole general meeting thing where you're supposed to be going and voting. But it sounds like shareholders don't actually use any of those provisions in the legislation. Or it seems like there is a big block of shareholders that dominate and are able to really do away with any opposition. So the idea that shareholders go up and participate in everything is ludicrous. It is really only likely if it's a small company. If it's a large company like Amazon or Google, can you imagine all the shareholders actually doing anything? One little person going up with their 4,000 shares, putting their hand up in a general meeting? Yeah, it can be a comedy show. So the idea then becomes, if you're working with this notion that the shareholders are participating and governing the company, it's a wrong notion. There are other people governing the company. We usually immediately, we know shareholders don't do a thing. But then we go through and say, yes, there's a Ministry of Corporate Affairs, there's your regulator. But the question, I suppose, is who else regulates? And here I just put up a little discussion question for us, just to look at all the actors who might be participating in regulating the company, and just to see how they might participate in governance of a corporation. So we're moving away from the statute, and I agree that each of these might be regulated by some statute. So of course your competition and consumer laws will regulate the consumers, your labour laws will regulate the employees and so forth. But I'm talking about how they might actually in a market try to see or try to direct the corporation, and it's an open question. So I was wondering if perhaps, what's happening? Right, my watch must be so wrong. Right. Okay, so the idea here is what are the groups? And it's just a question to raise some kind of, I suppose, just to think outside the box of the statute and the government and the regulator being the only parties who might regulate. And most CEOs look, when they're working as a CEO of a company, have to consider other actors. And they will change their behaviour depending on the actors, depending on all these actors. So I was wondering, in the shadow of the law, these actors also operate. So how do they? I don't know, do you feel like a small group discussion where you sort of talk among yourselves and present something? Might be nice. Afternoon, you know. Yes, we'll do it. Now, I want you to make sure you give everybody, I've got 2 daughters, and as I always say, I've got to give the other person a chance to talk as well. Because my older one doesn't talk, my younger one talks non-stop. So you've got to give everybody a chance to talk. That's my only guideline here. Give everybody a chance to talk and nominate one person to present how the individual actor might be able to direct the company's conduct. Which actor would you like? Why don't you have creditors? Unsecured. What about, maybe you guys want to meet, oh, are you guys from the same place? Oh, then you don't want to. The 3 of you should join up. Are you from the same place? Okay. Are you from the same place? You've got to join. Oh, actually, go there. You can join there. Well, tell me how you're going to talk. How are you going to talk from here to there? No, you can't. Okay, there are 3 of you. Do you want to talk about, what do you want, customers? You want to talk about the green customer? Maybe not, just customers. What about you 3? Employees? Which community? Do you two want to join those two? Oh, look at that. Maybe you guys should come here because these guys don't want to move. So which group do you want to talk about? Shareholder. What? Oh, okay. Minority. Minority shareholders. Minority shareholders. You're not doing anything, sir. How about you? No, you're separate group. Which interest group would you like? With customers is gone, creditors is gone, shareholders is gone, community is gone. Okay, talk about the state government and how they might direct companies. Your own state government. You, sir, don't have to do anything. No, actually, you should join somebody. I think you should join these people. No, he should join them. Thank you very much. A likely ploy there. Lovely. You can have 5 minutes, and I'd like you to elect one person to speak on how you think that actor is able to impact on the company's decisions. So what are you all looking at? So you're looking at, sorry, which you're looking at? Customers, right. So how customers' interests are protected indirectly through laws, but also through, what about codes? Anything? What do you think? What else? Okay, no, I think that's interesting. Yeah, good. Maybe, what about, I just want to suggest to you, what about a faulty good, like a faulty pharmaceutical? Like how customers use it, and then there's usually NGOs that kick and scream, and directors recall the whole product. So sort of, because consumer power, when something goes wrong, no. No. Yes. Yeah. Okay, maybe then I can ask you, are there any big shops or banks that have complaints mechanisms inside their own institution? You know, because they don't want to go to courts. You know, that might be like a reaction to keep consumers quiet. And it's just an idea. I like your independent director. I like the way you're suggesting that the whole law has shifted. Because what the point you're making really is that although originally the idea was shareholders are the main beneficiaries, what you're saying is indirectly the law is recognizing all the others as well and trying to give them a voice through putting other people in to watch for them. I like that. Oh, keep up.
A little stumped because we don't know what rights an unsecured creditor would probably have apart from, say, threatening to crystallize the claim of the floating charge holder or, say, threatening to pass a binding order against the company. But apart from that, we don't really know.
Yeah, that's true. Well, I suppose one thing you can say is that even though the company is supposed to be taking care of the interests just of shareholders, creditors seem to have suddenly risen to the top, and there are processes in place within the law itself that tries to protect creditors. So you're asking the question about the creditors' interests almost trumping that of the shareholders, and have they been able to wield enough power to have legislative change in their behalf? So that's one thing. Second thing, is there like bad debts registered?
No, so there is, I mean, you're talking about how the position credit is gone up, right? So, in terms of secured creditors, there's certain rights. It's different legislation that are coming into place, and others which not so easy, but something like the surface, it allows a secured creditor to collect on the debt without having to go to the court. If the creditor has a secured asset, so you can sell it off and recover and use use. That's not true for somebody like an unsecured creditor for which there are very many specific legislation. And the idea that position credit is gone up also something that is usually talked about when it comes to companies that companies are supposed to take care of credit and all the time when the company's function has to be concerned with different mistakes against the unsecured creditor has, and then usually the individual is going to go through very for the next.
Which is unlikely.
Oh yeah, I mean, it's more readily there is a specific or they could, I mean, there's certain provisions that you talk about the rights of the companies if they are unable to pay their rent, that would be illegal because again, pass it on as that regard.
Okay. Except the point you made before about a guarantee. But only in small companies. Except the point you made before of guarantee of a director, except in only in small companies, not large companies. To the point you're making, and it's a good one, that maybe creditors' interests are further and further protected by statute. Secured creditors, but not unsecured. And so unsecured creditors have to either get security or they have to actually try to use some kind of
forward schemes that the creditors would approve, but the operational creditors are usually excluded from the scope of this creditors mandate.
Good. It's interesting, isn't it? It's fascinating that unsecured creditors do lose out, especially if secured creditors are going to be part of the management team.
Do you have any answer to the process?
The only things is really we have things like bad debts registries, that show that certain companies have continually not paid certain creditors, and that might work when you go back to get loans later, and even when the directors may go to get loans later. But other than that, all you can argue is guarantees to protect yourself because you've been silly not to be secured. Okay, we're going to wind up now. Are you all right? Are you guys good? 1 minute? Okay, your friends have gone. Oh, that's good. That's good. All right, well, here they are. Good. Come back. All right. So what are you talking about, guys? Oh, great. Do you want to start? Just because because you don't have to start. Okay, that's fine. All right. So, okay, I think we should regroup. Now, the idea of this is not that there's a right answer or a wrong answer, but it's just to make some connections about all the parties that can actually influence the way a company operates, and just to see how much the law might have changed, and also to see whether they have to go beyond the law to get help or whether they're just left in the cold. So it's just to see who the company actually, whose interest the company takes care of. To remind you, traditionally, you remember, it's supposed to be the shareholders that are supposed to be considered by the company. So we're looking firstly at shareholders. The group there look not at majority shareholders, but minority shareholders. If you want to talk about both, that's fine. Go for it. Okay, thank you for that. So just to go back about how company law might have changed through time, if you look at the old laws, the original laws that told us how a company functions, as you know, they tell us about a general meeting and how the general meeting should work, and they tell us about the board of directors and how the board of directors should work and what are the benefits that shareholders should have. But over time, it has been understood that shareholders are often not just one group, but there is minority shareholders who are ignored. And the law is concerned with unconscionable conduct, with fairness. And in an effort to introduce fairness into company law, certain protections of minority shareholders have been introduced. You can argue that on two bases. The first is fairness, and the second is democratic principles and democratic participation. That it's not just the majority who should have a voice, but also the minority should have a voice in certain circumstances. Not all, but certain circumstances. So this is just showing you how the law itself has changed over time to accommodate minority interests to some extent. We'll come to class actions later on, but this is just, it's a good example of the change of law over time, not just majority. Majority can voice in a general meeting. The second group that we want to look at is creditors, I suppose, and this lovely group here is going to tell us about it.
So in terms of creditors, we were asked to especially emphasize the unsecured creditors. And we came to the conclusion that don't really have any rights. So unsecured creditors are usually individuals or operation creditors. Usually they aren't creditors who need a substantial amount of money without a guarantee or a supervision. So that would be in terms of their them driving corporate governance, they don't really have much of
Okay, so it's a very interesting point just to follow that theme, that a corporation is supposed to be about insiders, not outsiders, and directors are supposed to be acting in the interests of insiders, not actually shareholders, not really creditors. But the evolution of the law has been that the creditors have been a really important voice, strong force in bringing about the change of law to protect their interests. So the law prescribes a way in which security can be registered, how interests can be determined, and if you follow that process, your interests are registered. But if you don't follow it, as the point is made, you're left out in the cold. So this is again a shift of the law to try to embrace certain special outsiders into the company. Because if a director is trading while insolvent, if a company is trading while insolvent, the director also can be up the breach of duties. So the idea here is that creditors are a special category who have been able to impact on how a company functions, which isn't originally the thought. All right, thank you. The consumers you were talking about, or customers. The point being made is that their interest, perhaps, unlike the creditors, is not predominant, they're not protected, but perhaps they are through the positioning of independent directors to provide greater scrutiny. Okay. So I'll just put up the slide that you look at the trigger chapter that's there. There are some discussion questions about the Cadbury report of the UK Codes of Conduct. There's a Maxwell case that's been extracted on page 17 and the role of audit committees. So they're just some discussion questions that you might think about while you're doing the reading. I also wanted to say, for those of you who haven't done corporate law before, who are they again? Okay, there's 1, 2, 3, 4, just 4 people, 5. So maybe we can have like an hour discussion sometime where you can just have a bit of a chat to me about the kinds of issues you have, and if you need another hour or 2, we can factor that in. So not tomorrow, but the day after tomorrow. Maybe if I can ask you, maybe even lunchtime where it's free, you can just come up and have a chat to me. So I'll give you the room details and the time details tomorrow, and let's do that so we get up to speed. Other than that, I shall see you tomorrow. Same place, same time. Bye for now.